We are coming up on 2 years since the overturning of Roe v. Wade, and now a new challenge to reproductive rights will be presented in oral arguments before the United States Supreme Court next week. The case comes from the Fifth Circuit Court of Appeals after Trump-appointed judge and fan favorite amongst far-right special interests, Matt Kacsmaryk, ruled against the FDA and its decision to make the abortion pill mifepristone more widely available. My next guest actually testified on Capitol Hill this past week that this case is not just an attack on women's rights, but on federal agencies and their ability to provide what's right for the American people. Joining me now is Skye Perryman, the president and CEO of Democracy Forward. Skye, thank you so much for being here. This is such an important conversation to be had. Constantly we're seeing attacks on individual rights, but to have this one now before the United States Supreme Court, the highest court in the land that can dictate the law across the United States, is something that we definitely have to talk about. Some people are calling this case the, quote, next Dobbs, but what exactly is at stake regarding the availability of abortion pills like mifepristone?
Yes, this week the Supreme Court will hear oral arguments in a case that is critical for the ability of people to be able to access the most common form of abortion care, which is medication abortion. Mifepristone has been approved by the FDA for nearly 2 decades, and it is safe and effective. And FDA's experts have regulated the medication, have made it more available to people based on science and evidence and the views of the experts, and extremists are seeking to substitute their extremism for science and evidence and for the safety of this medication.
Skye, I think it's really important that we always traffic in facts and evidence, and I'm glad that you just brought it up a second ago. Mifepristone, it is available in 90 countries. It's increasingly being put on essential medication lists as well. The FDA has only received reports of 28 deaths out of 5.6 million people who have used the drug since its approval in 2000, and even those deaths cannot be confidently attributed to the drug. How much of the actual science in medicine is actually being considered here?
Well, the Fifth Circuit's ruling would take, and this is the ruling that's at issue at the Supreme Court this week. It's a ruling that is not based on law, and it is not based on facts. The FDA has reviewed the extensive record of safety and efficacy of mifepristone. Again, it's a more than 2-decade record, and it is concluded that mifepristone is safe and effective, that it can be available to people through telehealth, that it can be widely available to people. And the Fifth Circuit's ruling, if the Supreme Court allows it to stand, would take us back to a time where this medication was much more restricted.
And Skye, what's also important, too, is this is somebody like Matt Kacsmaryk and the Fifth Circuit trying to replace the judgment, the wisdom, the experience of the FDA. That's a federal agency. What do you predict is going to happen with the particular makeup of our SCOTUS, of our Supreme Court right now, when they hear these oral arguments and they render a decision later on?
The important thing to remember is that there are so many experts. It's not just the FDA, but it's the American Medical Association, the American College of Obstetricians and Gynecologists, the medical industries, pharmaceutical industries, former FDA commissioners, all weighing in here to urge the Supreme Court to reject the baseless arguments that the Fifth Circuit has adopted from extremists. What we do know is if the court declines to reject the Fifth Circuit's holdings, if they adopt the views of these extremists, that it would be devastating for women across the country who are seeking to access this medication that can often be life-saving and incredibly essential.
And Skye, while I have you here, I wanted to ask you about this new guidance that was issued by the Federal Judicial Conference, and it's basically to prevent judge shopping. I brought up Matthew Kacsmaryk's name at the beginning of the segment because it's really important, because he has been the tip of spear judge for a lot of these really radical, very draconian laws and bills that are being pushed by people who are trying to steal our individual rights. This guidance basically says that you can't file a lawsuit in a courthouse where the lone judge is known or suspected to be sympathetic to a particular cause. How dangerous is it to allow lawsuits like this one that's challenging mifepristone that made it all the way to the Supreme Court? How dangerous is it to allow judges like Matt Kacsmaryk to continue to have and hear these cases on his audit or his docket simply because people are trying to judge shop and get that in front of judges like him?
Katie, I'm really glad that you're asking me about this because this is really significant. This case should not even be in the courts. The Alliance for Hippocratic Medicine, which is the plaintiff in the case, specifically sought to incorporate in Lubbock, Texas, in order to bring this lawsuit that is baseless. The plaintiffs have never prescribed mifepristone. They've not been harmed in the case. And so we really hope the Supreme Court will reject this baseless attempt by extremists to even have their case in the court, and then, of course, reject their arguments as well.